Hi, everyone. This is your friendly neighborhood LCA professor, Professor Dimitri. What I would like to do with this short video is just share a brief, outline of how to effectively read and brief cases and why you might want to write case briefs for the cases that you read in LCA. I have a short PowerPoint here that I'm going to use to guide us in our discussion. So here we go. Okay, so let's talk first briefly about case briefing and what it has to do with assignments in this course. So when you're working on assignments in this course, why might you want to brief cases? Well, reason number one is that you're new to reading and understanding cases. It's going to take time for you to really get the hang of how to do that effectively. So briefing cases is going to help you practice the important lawyering skill of reading and understanding cases. That's reason number one. Second, briefing cases is going to help you take and keep good notes on the cases that you are going to be reading in this course that may apply to assignments. So what a case brief allows you to do is, instead of having to read the whole case again, you've got a short but to the point set of notes through your case brief that you can go to find the important information you need from the case. So that's reason number two why you might want to brief cases for LCA. So then let's talk about how to go about reading cases, and specifically what is effective for helping your brain absorb what you need to absorb in the most effective way. And this advice is actually based on brain science. I'm really kind of a science buff when it comes to understanding how our brains read and process information. So this advice with regard to methodology is based on that kind of science. So as you likely noticed through not only reading materials in this course, but in your other courses, that reading cases is unlike other sorts of reading that you've done in the past. It's hard and probably pretty frustrating right now. And that's natural. You're still learning how to read cases effectively. But it's important that you understand what the cases that you're going to be working on in this course, it's important that you understand what they say and what they mean, especially if that case is going to, when you get out into law practice, help you to advise a client or advocate for a client. So, and as I want to emphasize, the skill of reading and understanding cases will come over time. It's just a matter, as I've already pointed out, of practicing. You're not going to be an expert right away. You need to be patient. It takes time to learn the language of the law. So as you read more and more cases, you'll pick up these skills more quickly. All right, so methodology. Let's talk about step one. And I think this is really important, is that I would recommend that you print the case. And we'll talk about why that is in a minute. You certainly could read the cases on screen, but I will cover here very shortly about why it's more effective to read and print than it is on a screen. So second recommendations, after you've printed out the case, what I would suggest you do is you read through the whole case without taking any notes. Just take it all in. Read through it in one pass. It's okay if you don't get everything out of it on that first read. In fact, you're very, very unlikely to get everything you need to get out of it on that first read. It's just a very focused type of reading that you're going to need to do. So reading something once, you probably know if it's complex stuff, you're not going to absorb everything you need to know. Step number three, and this is really important too, is that you're going to come across terms that you're not familiar with. Law practice involves a fair amount of specialized terms. So I recommend that you get yourself a law dictionary. The most prevalent one is Black's Law Dictionary. You can access Black's Law Dictionary on Westlaw by just logging into Westlaw and with your username and password and searching for Black's Law Dictionary. That should take you directly to a link that includes Black's Law Dictionary. And then you can just type in the term that you don't know the meaning of into the search box. So for example, a term we're going to talk about is the term prima facie or prima facie. It's pronounced both ways. You probably don't know what that term means right now. We're going to talk about what that means in a future LARC class, but that might be an example of a term that you might look up in Black's Law Dictionary. All right. Then the next step is to read the case a second time. And the slide here says physically engage with the text. What do I mean by that? Well, that means that you should either highlight what you think is important as you read through, take notes in the margins next to portions of the case that you think are relevant. And that way, by physically interacting with the piece of paper, you're going to absorb more information. You're going to remember more information. And this, as I've mentioned, this is based on real science. Neuroscientists have studied how readers absorb information, and we're as human beings primed to interact with our environment physically. So if you interact with the page physically, chances are you're going to remember more, you're going to understand more of what you're reading. And then after you've read through a second time and you've taken notes and if you've highlighted, if you like to highlight, then it's time to write your case brief. And let's talk about, at least for the purposes of this course, these are the components of the case brief I would recommend. The thing you should understand also is if professors in your other course have ways that they want you to brief cases in those courses, then follow their format for those courses. And this is by no means the components I'm going to talk about for what I recommend for LCA case briefs. I'm not going to force this on you. You can choose to format things differently if you find a different way that works better for you. So, component number one of the case brief is going to be facts, okay? And when I talk about facts, these are the facts from the precedent case that were relevant to resolving the issue or issues that were presented to the court. So any fact that the court felt was relevant to its decision of the issue or issues should go in your facts section. And you're not going to include every single fact from the case because not every single fact is going to be relevant. You really want to try hard to zero in on what's relevant to the issues. The next component is procedural history. And very simply, the procedural history is the story of the case's progress through the litigation process. So, what most of the cases you're going to be reading are appellate court cases. So what happened before the case got to the appellate court? How did the trial court handle the case? How did the trial court dispose of the case? That sort of thing. That's what's going to go in your procedural history. And you want to focus only on those events throughout the course proceedings that are relevant to the issue or issues that the court, in the opinion that you're reading, felt were relevant. Then issue, or you may have multiple issues. Very, very simply, an issue is the legal question that the court was asked to answer in the case, and it does so through the course of writing its opinion. You may have more than one issue, just understand when you're reading a case. The courts often consider multiple issues in the course of an opinion. So, and I want to talk briefly about two different kinds of issues. One is a law-based issue. A law-based issue usually involves the question of whether a particular cause of action exists or should be created when the jurisdiction that the court is in doesn't currently have a cause of action for the particular issue. or if there are several potentially applicable rules of law, the court might be deciding which is the correct rule to apply. So a law-based issue has to do with the choice of a cause of action or rules that may apply. In contrast, and actually I shouldn't say by contrast because it's not necessarily going to be different from a law-based issue. And in fact, you often have a law-based issue and other kinds of issues in a case. But the second general type of issue is a fact-based issue. A fact-based issue is an issue in the case that involves a question of how an established rule of law, in other words, a rule of law that the court and the parties agree should apply to the case, how that rule applies to the facts of the case. That's what a fact-based issue is. So it's not unusual for a case to perhaps have a law-based issue where the first step in the opinion is for the court to decide, well, what's the rule that applies? And then after the court decides that, then it applies that rule that it finds that applies to the facts of the case. So law-based issues, fact-based issues, you may have both types of issues in a case that you're reading. You may only have one type of issue. It's just going to depend on the type and on the case. Then you have your rule of law or rules of law. Okay, a rule of law is a statement of the legal test that the court applied to resolve an issue that the court was asked to resolve. And there may be more than one rule of law in a case. The number of rules is going to depend on the number of issues that the court was asked to resolve. So if you have two issues in the case, chances are the court's going to be applying two rules of law, one for issue one and one for issue two. And then we have the holding, or if there are multiple issues, holdings, plural. A holding is the court's decision on an issue it was asked to resolve. So in other words, how does the court apply the rule to the case? That's what the holding is going to be. Then the court's order. This is the court's action under its holding. So for example, if you're reading an appellate court decision, the appellate court might agree with the trial court's decision and thus affirm the trial court's decision. It might disagree with the trial court's decision, so the appellate court might reverse the trial court's decision. Or the appellate court could not only disagree with the trial court's decision and thus reverse it, but the appellate court also remand the case to the trial court for the trial court to conduct further proceedings. A remand means that the appellate court is sending the case back to the trial court. That's what remand means. And then we have the reasoning of the court in the opinion. So, and this is really important. I mean, essentially the reasoning is the court's explanation of why it held the way that it held with regard to the issues that were presented in the case. Extremely important part of your brief, not that any other part is unimportant, but the reasoning is really important because judges and lawyers want to know the reasons why a particular legal issue is resolved the way that it is. The reasoning is extremely important. So that, in a nutshell, is a sort of overview of how to read and brief cases. I hope you found this helpful, and thanks for your time.